John Kamin is leading our annual legislative update, and we also have Tamina joining us. Tamina, do you want to get this party started?
I will, absolutely. I'm all about parties. I wanted to say thank you. I know we're all thankful for something, but I wanted to say thank you to all of you for joining us, not only today, but throughout the year. We are so grateful and so appreciative of your loyalty and your confidence in us. I know this webinar in particular is very highly sort of anticipated at the end of the year, and we love that John puts this together for us. So my special thank you to John for doing this. We have almost 700 attendees registered for this, so we're very grateful for that. I'm also grateful for 25 years at B&B. I completed my 25th year this year with Bradford and Barthel. I am the managing partner for client relations, as some of you may know, and it's been wonderful working with Tammy and Sherry, Dwayne, and Janine on my team for the last several years, and I'm grateful for my team. A friend of mine sent a poem about being thankful, and I just wanted to say there's a couple of lines that really resonated with me. It said, "Be thankful that you don't already have everything you desire. If you did, what would there be to look forward to?" And in keeping with today's learning, there's another line. It says, "Be thankful when you don't know something, for it gives you the opportunity to learn." So with that, I'm going to pass this over to John, and good luck, John. Thank you all again for attending, and I hope you all have a wonderful Thanksgiving with your families and friends.
Thank you, Tia, and hi, everybody. Thank you for tuning in today. My name is John Kamin, and I'm a partner with Bradford and Barthel's Woodland Hills office, and I'm also director of the firm's editorial board, which is a fancy way of saying that I run the firm's blog. If any of you have any blog ideas, please let us know. You're always our best resource for blog ideas, because if you see it out there in the field or at your desk, chances are there's 100 other people who saw the same problem, had the same question. And so that's really the kind of stuff we like to tackle on the blog, is something that's going to help a whole bunch of you. And speaking of the blog, we do actually have a related blog, which we just posted today. So if you happen to forget today's presentation, and in January or February, for example, you might need to remember parts of today's presentation, well, just go to the blog or Google it, and yeah, you'll find a blog all about the COVID presumptions expiring. And it covers some of the same stuff today. Now, a bit of background about myself. I was a journalist at Arizona newspapers for about 6 years, and then proceeded to work for WorkComp Central. And I was the legal editor at WorkComp Central, where I covered appellate case law and legislative developments in all 50 states. And some fun facts, I'll have some Thanksgiving related fun facts. While we're hosting Thanksgiving this year, if you're in the San Fernando Valley area and you don't feel like cooking, check out the Odyssey's Thanksgiving buffet. It is quite wonderful and extravagant. If you want to see 1,000 donuts on a wall or other extravagant things, that's the place that'll do stuff like that. And as far as some good TV viewing for the weekend, we're excited about Fargo opening up tonight, one of the good annual shows. And also Murder at the End of the World just started. If you like a thriller, that one's also a little bit creepy, but it'll keep you on your toes. So with that being said, let's get started with what we're going to cover today. So first of all, we're going to open the presentation while talking about the COVID-19 presumptions that all expire on 1/1/24, and what that means for employers and adjusters and attorneys and defendants, and what it means for after 1/1/24. Because sure, these presumptions are expiring, so great, what do you do next? So we'll cover that. And then next, we'll take a look at presumption bills that were vetoed by Governor Newsom this year. And the reason why we'll do that is similar bills will probably be proposed next year. And we'll also look at holdover presumption bills as well for 2024. And those are bills that were introduced this year, didn't quite make it through committee, and they're being held on to next year. So those may regain new life, like Dracula next year, for example. After that, we'll cover a few of the approved bills, a preview of the 2024 legislative session, reforms we would like to see, And then the three big cases you have to know about from this year. There are three big ones, and it wouldn't be a complete presentation if we didn't give you a refresher on those real briefly. So which COVID presumptions expire on January 1st of 2024? Well, all three of them, in fact. Now, the first one, that one ending in .86 at the top of your screen, that one only covers dates of injury through July 6, 2020. So we haven't used that one for, a few years now. Sure, there may have been some late reported claims, but that one probably hasn't been on your desk recently. It's the second two, the first responder presumption and the outbreak presumption. Those are kind of the big ones there. And the outbreak presumption is the one that all employers have to send in all that COVID reporting data, so all positive tests, whether it's industrial or non-industrial, to their third-party administrator. So that's the big one that's going to affect all employers. So you can hear, for example, the California Chamber of Commerce and businesses across the state being happy with the expiration of that. Now, one common and very good question is, but wait, weren't these extended by a prior bill? And the answer is technically yes, but when they did the extension, it was to extend it from 1/1/23 expiration to 1/1/24. So the extension actually happened last year, and it extended it to the end of this year. So in other words, the last year has flown by, if you're thinking of that question. And so then that begs the next question. Well, aren't they going to extend it again? Well, the deadline to send bills to the governor's desk has passed. That ship has sailed. He issued his approvals and vetoes now about a month ago. And while it is possible that he could call a emergency legislative session and scramble together, the state Senate and the Assembly to get new legislation to extend them, that's probably unlikely barring an absolute catastrophic outbreak. And I don't think that's very likely. We are seeing some outbreaks across the state, but definitely nothing like December 2020 or even December 2021 or January 2021. Those years had pretty big outbreaks. This year's, it seems a little bit more, or a lot more limited, I should say. So I would handicap that as odds of 10% or less. So pretty small chance of them extending these presumptions due to a catastrophic outbreak. So what does this mean for defendants? Well, first of all, you can tell your employers you don't need to do that COVID outbreak reporting after 1/1/24. There's no need to report to your adjusters every single positive test. Now, that being said, if you do have employees who are telling you, gee, I think I got COVID from work, well, then you should hand them a DWC-1 claim form and report that to your claims adjuster or your TPA. What it means for adjusters and attorneys, no more need to calculate 14-day outbreak periods for dates of injury after 1/1/24, and no more need to ponder the question of which presumption applies after 1/1/24. That would come up when you would have someone who might be a first responder, but you aren't quite sure. So then you'd have to consider first responder presumption and outbreak presumption for those employees who fell into those gray areas. Another thing that it means is no more shortened decision timeframes of 30 or 45 days for COVID claims. Instead, it reverts back to 90 days to decide compensability. So for most laws, expiration date of 1/1/24 is standard boilerplate. But in this particular scenario, it's interesting because, as we just noted, COVID rates really tend to spike during the holiday season. And so those outbreaks that ran through December 2021 and January 2022, if stuff like that happens this year, you may have some wobblers. And a wobbler is a criminal law term of art to describe charges that could either be prosecuted as a misdemeanor or a felony. And here, the work comp COVID wobblers would be, a case where you may have symptoms start in December of this year, but the positive test isn't until January 2024. So we'll talk briefly about those right now. So here's some basic criteria to kind of figure out what to do with those cases. So if your symptoms started on or before January 1st, 2024, I would recommend treating it as if the presumptions apply. If there's a positive test on or before January 1st, 2024, again, treat it as if the presumptions apply. You're playing it safe. And what I mean by that is issue a timely decision, within the shortened decision time frame, depending on which presumption you're using, and treat it like that. The worst that would happen is that you would make a decision early and have a timely decision. Now, if symptoms start after January 1st of 2024, logically it follows that your positive test would be after that date. In that scenario, the presumptions would not apply. And now, if you're unclear, and if it's really vague or down to the wire, and you don't have all the facts, again, treat the claim as if the presumptions still apply. The worst that's going to happen is that you make a decision early and timely. So abide by those 30 to 45-day decision timeframes. And if you're still unclear, or if the facts are really crazy, feel free to send an email to the COVID desk. That goes to me and our COVID team, and we'll be happy to analyze that for you and let you know what we think. Now, looking forward, what do we do after January 1st, 2024, when those presumptions have gone and that ship has sailed? Well, it will be the same standard as when a presumption does not apply. So what's that standard? Well, the burden of proof is on the applicant to show that they got COVID from work. And it's by preponderance of the evidence. So think 50, 51%. They have to prove that work put them at greater risk of contracting COVID than their non-industrial life. And again, 90-day decision time frame. So the way you're going to investigate those claims is very similar to the way you already have been. You want to look at all sources of non-industrial exposure and really do that fact-heavy investigation. So for example, look at family members. Is there concurrent employment? Public transportation, such as buses and airports, carpools, concerts, vacations, holiday parties. And unfortunately, COVID that happens in Vegas, unfortunately, does not always stay in Las Vegas. And that's been pretty well documented. A lot of viruses in Vegas the last few years. So unfortunately, people were going there and then going back home and bringing the party back home with them, unfortunately. So anyway, you want to take a look at stuff like that when you're investigating these claims. So what about testing? As you may recall, the first responder and outbreak presumptions required PCR tests because those are more accurate than your antigen or rapid test. So looking forward to 2024, a PCR test on every single case would be nice to have as the standard, but technically it's not going to always be required. So what if you have an employee in February of 2024 who says, hey, I tested positive via a rapid test? Some form of authentication is going to be needed. So you could do the newspaper example, although we don't really have newspapers around as much these days. I guess you could also take your cell phone, which has time and date on there, and put that in the background. But then where are you going to take the picture with? Still, some form of authentication is going to be needed to prove that the picture of that at-home test was on such and such date, such and such time. And if that isn't there, someone else could have honestly taken the test. For example, if my 6-year-old has COVID and I want to pretend that I have it, Tia, I don't want to go into work today. I could have my son take the test and then take a photo of it and pretend it was mine. And who would ever know? No one would really know. So that's why I recommend some form of authentication on test as we go forward into 2024. Now, PCR tests, you don't have that same issue because those usually have the person's name and date on there. So those are already kind of self-authenticated by the labs and the doctors who are administering the PCR test. And going back to the rate of accuracy, PCR tests are much more accurate than antigen tests. And it's hard to fake a PCR test. So if Bob wants to, so for example, if Jack wants Bob to take a PCR test for him because Bob has COVID and Jack does not, that's kind of an elaborate scheme to send Bob over to the testing facility, pretend he's Jack, and then take the test for him. It's not very feasible that people would do that with a PCR test. Whereas with an antigen test, it's much easier to do something like that. And so going back to people using the rapid test in 2024, and Tammy, do we have a question?
We do. Is the labor code going to be amended to include rapid tests? It's pretty clear regarding the PCR test.
So actually, no. What's interesting is that these statutes, labor codes that created these presumptions will be treated as if they no longer exist. So those sections are effectively disappearing from your labor code, and they aren't being replaced with new language, at least that we're aware of. So that, and frankly, something to that effect would be useful. So there's going to be a bit of a gray area there. So part of the reason why that's a good question is looking forward to 2024. What if you have someone who just has a rapid test? Is that going to be a problem? Well, your circumstantial evidence can help you with that too. As remember, you're doing a pretty detailed factual investigation. So you see what the coworkers say. Well, Jack was coughing on Tuesday. And then you look at the doctor's report from urgent care who said Jack has COVID, and the dates line up. And then you see that they authenticated their rapid test next to a newspaper or a smartwatch. That's another good way to authenticate it. Your smartwatch has the date and time on there. And that rapid test says positive. And then your claims adjuster calls Jack to talk to him. And gee, he didn't sound good at all. Well, if you have those 4 facts lining up, yeah, you should probably, you could lean toward accepting that. One last note about the rapid test. The reason why they're less accurate than PCR test is the area where they're missing is the front end of the COVID exposure. In other words, rapid tests have a lot more false negatives. So they say that Jack doesn't have COVID, when in fact, when Jack takes the test again in 2 days, it's going to be positive. Whereas the PCR test is much more accurate on day like 3 of infection, for example, or day 4 of infection. So that is the edge that PCR tests do have over rapid test. But one reason why I'm talking so much about this is we are looking at the price of the two. These days, even if you have insurance, the price of a PCR test is $170 when it used to be free. Whereas a rapid test, you can go buy from CVS for 10 or 15 bucks, or buy it on Amazon. So you aren't going to see as many people being willing to go get those PCR tests because it's almost $200. So that's one reason why you may see fewer PCR tests going forward. Now, let's look at other presumption bills from this year, which were also vetoed. So AB 1145, this created a new PTSD presumption for state nurses, psych techs, and other providers at state prisons and psych facilities. But that's not law because Governor Newsom gave it the veto stamp. So no new PTSD presumption for those workers at state facilities. SB 391 would have made more officers from Fish and Game, Parks and Rec eligible for skin cancer presumption. Again, that got the veto no stamp, so that is also not the law. And then moving on to AB 699, this would have expanded the existing presumptions for the City of San Diego Fire and Rescue Department's boating safety unit by adding biochemical substances, PTSD, items like that. Again, that was vetoed as well. What's interesting about those is those 3 bills sailed through the Assembly and the Senate with pretty good support, but Governor Newsom did veto them. And in his veto messages, he's being very careful with adding new presumptions to the labor code. Now, there were even more presumption bills that ran into significant problems at the Assembly or Senate in California before they could even get to a floor vote in 2023. And so these are being held over, these next few bills that we're going to talk about. And what's a holdover? Well, California actually has a 2-year legislative session. So bills that aren't passed in the first year and are being held over to the second year can be reconsidered in the second year. So these next few bills that we're going to talk about may be up for consideration for approval in 2024. So the biggest holdover that we got the most questions about was this one, AB 1156. So they're going to be talking about this one next year. And this proposal would create a presumption for employees at acute care hospitals who provide direct patient care. And it would presume that infectious diseases, orthopedic injuries, PTSD, cancer, and various respiratory diseases are work-related. So you read that correctly. This is a potential presumption that a back injury could be presumed compensable if that is passed next year. One frequent question we got about that bill, see the word acute care hospitals there? Well, what is that? Does that apply to urgent care clinics or smaller medical centers? In the simplest terms, what they are referring to is really big hospitals where people stay overnight. So your urgent care places and smaller clinics, smaller providers, no, this presumption is not going to apply to them. Whereas your city's big hospital, it would apply to that. And that's important to know because a lot of different carriers cover a lot of smaller medical facilities. So that's another bill that's going to be kicked around next year. It got some significant talk in 2023, and maybe we'll see that in 2024. And I think we see a question there about whether it's going to include assisted living. I don't believe that it would apply to assisted living, as it's really more just the big hospitals. Another presumption bill that's being held over to next year is a bill that would add more employees from corrections and also CSU Police Department to the PTSD presumption. So sorry for the acronym salad, but basically it's a PTSD presumption for people who work in the Department of Corrections and also CSU. And it would primarily impact employees who are responsible for law enforcement, such as transporting inmates. And so that's another one that could be considered next year. And the takeaway from talking about these, and the reason why we're talking about these today, is these presumption bills that were vetoed and then the other ones that were held over, basically they send the following message. You have labor-friendly lawmakers who saw Governor Newsom support the COVID presumptions in 2020. And gee, maybe he'll support more presumptions for my stakeholders. And so then that lawmaker winds up pitching a bill, hey, how about this presumption or that presumption, whether it's ortho or respiratory diseases, and it gets support in the Assembly and House, and then it reaches the governor's desk and then vetoed. And Newsom has been pretty consistent with his veto messages. Here's the standard boilerplate you're seeing when you read the veto messages. Such and such is compensable under workers' comp. However, altering the burden of proof through a presumption should be sparingly used. And in other words, we don't really want to create a bunch of presumptions. And he says, well, it's well-intentioned. The need for a presumption must be supported by clear and compelling evidence, which is one of the highest standards there is. So really, unless there's a pandemic level catastrophe, it sounds like the governor is pretty resistant to approving more presumptions, and that's good. That being said, the bottom line, expect lawmakers to continue to follow the pattern by pitching new presumptions next year. And as we just said, we have good reason to believe that Newsom will continue to veto them, unless it's something really big like a pandemic. So let's turn the page and look at approved bills. So what bills were signed into law this year? Well, there's 3 of them that were worth noting. SB 623, that deals with PTSD and first responders. AB 621, limits on death benefits for state employees. And AB 336, that deals with contractors and trying to reduce misclassification of workers. So let's look at SB 623 first. This one postponed the expiration of the statutory presumption, which says that PTSD is an occupational condition for first responders. So that one was going to expire at the end of next year, so 1/1/25. But this bill kicks back the expiration date another 4 years, all the way to January 2029. So in other words, first responders are going to get the PTSD presumption for 4 more years. So basically for the foreseeable future. Another bill that was signed into law by the governor this year is AB 621. This removed limitations for death benefits for specific workers in the Department of Forestry and Fire. And so what it means, the shortcut, is just that families of firefighters can now, families of state firefighters, I should say, now can collect both work comp and CalPERS death benefits simultaneously. Keep in mind that's state firefighters. AB 336 is kind of interesting. It requires contractors to submit their work comp coverage application and their classification codes to the State Contractors License Board. And the intent is to prevent contractors from intentionally misclassifying their workers. Now, well, I like the impetus and thought behind this bill, but it doesn't appear to do much to deter the contractor who has a license, claims they have no employees, but in reality actually has employees who may get injured. And then they're going to try and push the liability elsewhere. So while that intent is good, it really doesn't do enough to deter unethical contractors. And besides the UEF and coverage problems it creates, allowing this problem to continue is also unfair, because out there we also have thousands of honest contractors who do pay their premiums, they do everything by the book, and here they are having to compete with these other guys who aren't doing that and are saving a bunch of money as a result. So it's not fair to the good employers and good contractors out there who are doing everything correctly. So that is something we would like to see maybe get more legislative attention in the future. So what else are we going to see next year? The big question is, will this year be the year of the omnibus reforms? We are overdue for a new reform bill, and the last reform bill was proposed and took effect years ago, but it never fixed things like the interpreter fee schedule, for example, even though it tried to. And we are overdue for a reform bill, as typically they happen about every 5 to 8 years, and we're around that time again. So here are some potential bills we could see next year. Bills attacking apportionment to non-industrial conditions. So expect to see some of that, and especially in the earlier months like February, March, and April, May, you may see some articles about bills like that. Presumptions, as we just mentioned. Bills attacking MPNs or trying to weaken MPNs. We've seen a few of those the last 2 or 3 years. And bills also trying to undo the UR and IMR process. And as you may recall, there was a bill this year that failed that basically would have created additional temporary total disability if UR or if IMR said that medical treatment that was denied by UR is reasonable and necessary. So in other words, if IMR undid the denial, then the injured worker who was already TTD would be entitled to extra TTD. So that would not count against their 104-week cap. So that was a bill this year that wasn't passed. That again is trying to add extra criteria to UR IMR. I guess that's the safest way to say that. Now, what are some topics we'd like to see in 2024? Well, one thing that would be great is CT reform and post-term CT reform, right? So what could that look like? Well, just spitballing here, but you could place a statute of limitations on a CT filed 2 years after the applicant was terminated, or even 1 year. Well, what about cancer and these other diseases that take a long time to manifest? Well, you could add exceptions for stuff like that. And then that way you're treating the poor applicants who have cancer fairly. If they didn't know when they were terminated that they had cancer and that pops up later on, they could still pursue a CT claim. But what this would do is it could weed out, for example, a post-term CT that's filed 2.5 years after the applicant was terminated or laid off. Another topic we'd like to see covered are additional panels. Right now, there's currently a movement at the WCAB to award additional panels in any specialty in any case for almost any reason. Now, what we'd like to see reform on is additional panels are granted only when they're clearly warranted. So in other words, we want to see some reform barring the unwarranted stuff. So if you have an applicant who has no history of treating for a body part, and let's say a judge does award a panel for that unnecessary thing that's being pled, you're essentially making every claim an oncology claim. Because what you're saying at the end of the day is that regardless of whether the applicant does have cancer, they could just simply plead cancer on the application for adjudication, right? And get a oncology panel on every claim, and there's no repercussions. Well, that's not fair. And it's a big waste of money, and it's a big waste of time. It drags out cases, and it's simply unnecessary. So what would reform on additional panels look like? Well, the legislature could specify factors on when an additional panel is warranted, such as, well, they do have a bunch of treatment for that condition. But I think the cases where I'm bringing this up to target is it's unfair to plead psych when on a post-term CT, especially when I take the applicant's deposition. And here's a direct quote from the deposition. I asked the applicant if he has any depression or anxiety, and he says, nah, man, I have a strong mental outlook on life. Well, in that case, why should we be threatened with having to pay a QME $5,000 to $10,000 for a psych eval when he's telling me that he has no psych issues, no depression, anxiety, and is, kind of laughing at that idea. Well, he's the one who pled it, or his attorney did at least. And so by getting reform on additional panels, it would deter firms who literally plead hostile work environment on every single claim, regardless of the facts. And I think we know who those firms are. And a lot of that is frivolous litigation. Moving on to another topic that could be helpful, another reform topic is standards for DME. So if a medical provider is going to bill for medical equipment, they should have to identify what materials it's made out of, what machines they used to make it, how long it took to make it, who made it, how many other DMEs were made that same day or month or year at the same facility, and sign that declaration under penalty of perjury. What that does is that could prevent certain DME providers or people who are billing extraordinary amounts for medical equipment and medical devices from hypothetically creating 100 items on the same day and then billing $10,000 a piece for each one. And then when your bill reviewer wants to find out, well, gee, what materials is it made out of? How much does this thing cost? What's the actual valuation of it? And then they stonewall on that because they don't want to show what materials it's made out of, how it was made, who made it. No, they want to be vague about that. Well, that's not fair when you're billing 5 to 10 times what the thing is worth. So I think that could be an easy reform that we'd like to see in the future. And I'll stop spitballing on reform ideas we'd like to see, but one last area that would be good is Patterson case law reform. Now the Patterson case, if you're unfamiliar with it, it bars carriers from sending an RFA to UR. In other words, you can't send that to UR when that treatment has already been authorized and when there hasn't been a change in condition. In other words, you can't send it to UR if those two criteria are not met. And that's the panel decision from the WCAB. What's the problem with that concept? The problem is that PTPs and work comp don't get more money to say someone is well. They do get more money by providing never-ending treatment. Some providers will never, ever, ever find a change in condition because why would they? There's no financial incentive for them to do that. And even if they did, their applicant's attorney friends are going to get angry at them for finding the change of condition. So by literally finding a change of condition, it is against all their financial interest. So some applicants' attorneys argue Patterson, but then simultaneously object to any attempt to do discovery on a change in condition. So on one hand, they're arguing defendants, you have to show a change in condition in order to send RFAs to utilization review. And then on the other hand, when you try and find out anything about the change of condition, oh no, you can't do that. So it's literally unfair. So some proposed solutions to that problem. You could specify that QMEs can comment on whether there has been a change in condition. And it's not a comment on future medical care, which is, yeah, the Sandhagen decision says that QMEs should not be weighing in on medical treatment disputes, but rather it's a comment on medical status. That being said, we still see pushback from judges who don't want to consider the QME reports in cases with Patterson issues. And that's not really fair, especially when you consider that the QME is just commenting on medical status, i.e. whether there has been a change in condition. Another simple addition to such a bill would be setting forth discovery rights for defendants to find changes in condition, such as additional depositions, independent medical exams, mandatory consideration of the guidelines, and consideration of ADLs. After all, the guide says that we should be using ADLs to determine impairment, so why shouldn't we be considering that for changes in condition? Another topic that would be, and we'll talk about the case that led to this point here, 5710 fee reform. So there's a WCAB ruling that applicants' attorneys cannot bill for administrative tasks, such as scheduling the depot, calling the applicant to tell them to go to the depot. We still see applicants' attorneys billing for these. And we see some applicants' attorneys even holding up settlements for 5710 fee requests that are intentionally set. In other words, they're demanding 25 to 50% above market rate. And some of these are even including administrative tasks. A potential solution, add some teeth to punish unethical behavior in that regard. In other words, holding a settlement hostage because the defendant didn't pay the exorbitant 5710 fee demand. Another topic is clarity on electronic service. At Bradford and Barthel, we have a clearinghouse address for service. So we tell everybody, hey, if you're a opposing counsel, serve us at that address, service@bradfordbarthel.com. But right now, the rules and regs do not require every firm to have a clearinghouse email account to accept service at. And rather than leaving things ambiguous and leaving parties with the argument, gee, I never got it, even though we sent it to them, a simple solution to all that is require everybody to use a clearinghouse email address for all law firms who practice work comp in California. That would solve all that stuff real quickly and probably reduce litigation by about 5 or 10%. So moving on, let's talk about the 3 big cases of 2023. And they are the grant and study decision, known as the early decision, the take-home COVID decision, also known as the Cusiemba case, and vocational rehab apportionment, Nunez versus DMV. So let's start by taking a look at the grant and study decision. So which court did this decision come from? It came from the 2nd District Court of Appeal in California. So it's 1 notch below the state Supreme Court. What was it on? Well, grant and study decisions, where a trial happens, there's a findings and award issued by the judge, and a party files a petition for reconsideration. And the more complex cases, the appeals board would grant the petition for reconsideration, but then add a sentence or two saying, well, we still reserve our right to more time to decide this case. And in some situations, that led to cases pending on recon for 3 years. So here's what you need to know. This decision issued by the appellate justices at the 2nd DCA still allows the WCAB to do a form of grant and study. What it does, though, is it says that they should be issuing more detailed decisions. And so this is resulting in new panel decisions granting recon within 60 days, but they still allow the board to take additional time to make a final decision on the merits. So in other words, the board can still take more than 60 days to decide your petition for recon. And that is a published decision that came out earlier this year. Another really big case that happened in 2023 is the take-home COVID decision, known as Kusiemba. So who made this ruling? Well, the California Supreme Court, so the highest court in the state. And the topic of this case was take-home COVID. And so an example is an employee allegedly gets COVID at work, and they go home and they give it to their spouse, and their spouse unfortunately passes away. So the question in this case is the employer liable for wrongful death? Here, the High Court said that employers owe no duty of care to an employee's household members to prevent the spread of COVID. In other words, the employer does not owe a duty of care to the employee's spouse or to other people living in the house with them, whether they're family members or roommates. And that was a big case. And as you may remember, it's a follow-up decision to the See's Candy case, which came out a few years ago, which said that in that situation, the employee could sue for the wrongful death of the spouse. But remember, See's Candies just simply said that they could bring the suit. It wasn't barred initially. It didn't cover topics like duty of care. And if you read the See's Candy case really carefully, you'll actually see Kusiemba, I think, mentioned in, or no, you won't see Kusiemba, but you will see other cases mentioned in there. So that is a landmark decision. Part of the court's reasoning in getting to that conclusion that the employer does not owe a duty of care is that it would literally swamp the courts of California with unending litigation. And the court system is simply not prepared for that amount of litigation. And in this case, the justices also pointed out that because every COVID case is different, it's not like you could solve that problem by lumping all those COVID cases into class actions. No, everyone has a different living situation. Everyone has different sources of non-industrial exposure. And so in short, the state Supreme Court used the often unused reason of public policy for saying that employers owe no duty of care. And what's also interesting is that the justices pointed out that the courts literally do not have the staffing or the budget to handle the amount of cases that would add to the dockets. So very rarely do you see a high court, whether it's the California Supreme Court or another state's Supreme Court, citing public policy as the reason for not doing something. But in this case, the public policy reasons so far outweighed the other reasons that they had to come to the conclusion that employers do not owe a duty of care to employees' household members, such as their spouse. Now, the third case, and we'll jump back to this 5710 fee case in a second, but the third big case of 2023 is voc rehab apportionment, also known as the Nunez en banc decision. And it's a en banc from the Workers' Compensation Appeals Board in San Francisco. So that means that all the commissioners weighed in on this one and signed on the decision. Now, the topic is voc rehab, and when an applicant's attorney's voc rehab expert intentionally ignores the apportionment given by your QMEs or AMEs or even PTPs in a case. So in other words, if you had a QME saying, gee, I find 30% apportionment of this back injury to the prior back injury from 10 years before. Well, you'd have applicants' attorneys, voc rehab experts intentionally ignoring that and trying to get away from that apportionment. And they would substitute it with their own voc rehab apportionment or vocational apportionment. And guess what? Their vocational apportionment would always lean toward making it a much higher value case. So they'd try and substitute the QME's apportionment that was not profitable for them and replace it with something that was more profitable for the applicant attorney, and try and turn that case that might be an 85% PD case into a 100%er. So here's what you need to know from this en banc decision. The voc rehab experts cannot ignore the physician's apportionment findings. So they can't ignore that QME's finding of medical apportionment. And they are not, these voc rehab experts are not allowed to substitute it with their own vocational apportionment or lack thereof. It also goes out of its way to say, listen, the voc rehab experts can still come up with alternative theories, but they can't ignore these very important findings from the medical experts in the case who are medical doctors, and these voc rehab experts are not. So one of the other key takeaways from this decision is that if you are working in a case with voc rehab experts, you as defendants want to really make sure that your expert is paying attention to what your medical experts say. So make sure that your voc rehab expert is paying attention to the QMEs and the MEs. And if they aren't, bring that stuff to their attention. You know, say, hey, can you write a supplemental report focusing on this, this, and this? You know, can you highlight these other details? And what that allows you to do is it allows you to point out that, hey, our expert has the most accurate medical history, and whereas the applicant's attorney's expert is really ignoring a bunch of important medical facts and findings. And bonus round, one last case to know about. We kind of touched on this earlier when talking about 5710 fees. This is a panel decision, and it's called Cohen's versus ABC Unified School District. And again, the topic of this one was 5710 fees. And this case, your appellate board panel or your workers' compensation appeals board panel said that services deemed inflated and purely clerical in nature, such as the scheduling of a deposition, notification of the applicant of the deposition, are not reimbursable as 5710 fees. So in other words, those purely administrative tasks should not be appearing on 5710 fee bills, nor should they be reimbursed either. And we felt that that was a pretty interesting panel decision. So we did post about that. I believe it was in August on our blog. If you want to read about that, or the other cases such as Nunez, Kusiemba, or Early, you'll find those on the blog as well. And actually, we do have some recons that have come out since the Early decision, which have that new language allowing the board to take additional time to review those grants and studies. So we do intend to have a blog kind of highlighting what your new recon decisions are going to look like. And we intend to publish that sometime before the end of the year here. And just a reminder about the blogs, we do have a blog that just went up about 2 or 3 hours ago about the COVID presumptions. And yeah, that's about it. Tammy, do we have any new questions that came in while we were presenting?
We do. We have a couple of questions. How do you prove whether they got COVID at home or work?
So, you know, obviously it's impossible to prove it to a certainty. Actually, no, that's not true. It is possible to prove it to a certainty if you get the original if you get the original urgent care center medical reports. So what you want to do is find out who lives in the house. So a common set of questions you'll want to find out are who lives in the house with you? What do they do for work and school? Were they sick recently? Sometimes the answer is yes, sometimes the answer is no. Feel out any vacations, because all the shared transportation that people incur while going on vacation, you know, airports, buses, taking people to their hotels, those are hotbeds for COVID as well. And the reason why you're asking about what the other people in the household do for work or school is sometimes there are outbreaks at a school, or sometimes the person works in a high-risk environment. And so if you see that and you find out that, you know, they had COVID around the same time, or their COVID predated your applicant's COVID, then that does help you disprove that. And another thing you can do is really definitely use subpoenas. Find out where the applicant went for medical care, and you know, where, even if they aren't being forthcoming, you can use Google Maps to find out if there's an urgent care center across the street from their house. And we have seen this come up where the applicant tells me at the deposition, oh, I'm 99% sure I got it from work. And then we get a medical report from urgent care saying, the applicant says she got COVID from her cousin last week. So that's why you really want to spend that money on those subpoenas, even though it does seem like a expensive cost. You know, that cost can lead to a non-industrial claim later on. And Tammy, what was the next question?
So if Jack says that he got COVID from a coworker at work, and that coworker got COVID from his 5-year-old son or at a party, is Jack's COVID exposure at work industrial? Sorry, I just want to make sure that made sense. But yeah, does that make sense to you, John?
Yeah, it does. And so in that hypothetical, if Jack's timeline checks out and Jack has a PCR test and the coworkers say, yeah, that coworker came in and they're working right next to Jack and they're sure we're coughing a lot. And then you know what? The next day he said, gee, I tested positive. So if all that stuff lines up, then yeah, Jack's COVID would be industrial.
Thank you. I think we just have one more. What about the admin fees from applicant attorney on responding to IMRs?
So that arguably that should also be, so that wasn't covered by the Cohen's decision or Cowan's decision. That really focused more on 5710 fees related to depositions. But I don't believe that those admin fees are appropriate, although I'm happy to take a look at that after today and take a deeper look at that. But yeah, I should note that the 5710 fee decision we were talking about earlier really was not on that topic. So I would be careful about applying that to non-deposition situations, the Cohen's case.
Thank you, John. Okay, I think that's all the questions we have for now, and we are about out of time. So a couple of quick reminders for you all. Certificates for CE and MCLE will be emailed to you this afternoon. I'm going to work on them right away. Our next live webinar is on January 4th with Tim Musak on COLA and the annual checkup. You definitely don't want to miss that one. You can register for it now on our website, on our training page. I just want to thank you all again so very much for joining us for any and all webinars that you've joined us for this entire year. And I hope that you all have a wonderful holiday season and a happy new year, and we'll see you on January 4th. Thank you so much, and thank you, John.
Thank you, everybody. Appreciate you checking in today.
Have a good holiday.